It's really, well, thanks for having me. It's really a pleasure to give a paper that, on the heels of many interesting papers in which this fits, I think, fits very nicely into all the themes that we've been talking about. It's not terribly controversial to suggest that intermarriage between Jews and non-Jews from the 19th century onward complicated the question of how one defines who is a Jew. After all of these papers this morning, this seems like an incredibly banal way to start my paper. But in any event, Jewish confessionalization and the creation of a Jewish state added further questions and competing authorities vying to define who is a Jew. And what I want to talk about today are instances when state courts have been forced to determine the criteria for membership in the Jewish community, and in particular, two cases where the controversy stemmed from intermarriage. And one or both of these cases may be familiar to people, but I'm not sure. So I'll give you an approximate outline of the cases in questions, one which took place fairly recently in the United Kingdom, and the other in Israel, which was settled in 1970. And I thought it had been settled. That's why I was asking you these questions, because about maybe it wasn't so settled. I have a few purposes in making this comparison. The first is simply to demonstrate that problems over how to define who is a Jew are comparable between Israel and the diaspora. In other words, it's not only Israel where this question has legal ramifications for Jews. The second is to challenge how these cases have independently been interpreted by scholars, not in a way that I agree with or think is correct. And the third purpose is to consider, maybe just by asking the question, given the time considerations, why questions of intermarriage in particular seem to become a source of legal contention. So the approximate outline of the first case, actually the second chronologically, but I'll say the first case is this. The Jews Free School in London, or JFS as it's called, was established in 1732 as a charitable school, a Talmud Torah, for orphans run by the Great Synagogue. And in the 19th century, the school was funded by sort of the wealthy magnates of the Jewish community, the Rothschilds, Goldsmiths, Montefiores. And today, like all of the religious schools in the United Kingdom, Anglican, Catholic, Muslim, JFS receives state funding. And in return, it's theoretically open to non-Jews. But the rules are that if a religious school is oversubscribed, meaning it has more applicants than it has spots, it can prioritize the admission for its own religious constituents. And actually, other schools Jewish schools in the UK have a large percentage of non-Jewish students in them. But the JFS is an old, good school, that has been serving a large Jewish community for a long time, and so it has always been oversubscribed and has never had any obligation to consider non-Jews for admission. So the essence of the JFS story is that a boy with a mother who had undergone a non-Orthodox conversion, a Masorti conversion, before he was born, was denied admission under the premise that the school could give preference to Jewish students. And the school defined being Jewish according to the halakha as interpreted by the chief rabbi of the United Hebrew Congregations, which is an official position, an official Jewish community. At the time it was Jonathan Sacks. And they defined this through matrilineal descent and did not recognize the halachic validity of the mother's conversion. So the father sued and initially lost his case, which he claimed racial discrimination, and then it went to a court of appeals in which he won the case. And it was the United Hebrew Congregations and the Office of the Chief Rabbi, Jonathan Sacks, who sort of pushed JFS to appeal this to the Supreme Court of the United Kingdom to sort of settle this issue. And they appealed the appeal and they lost. That is, the father won. Okay, so the second case I want to consider is one people may be familiar with, but that of Benjamin Shalit and his children. So Shalit met a non-Jewish woman while studying in the United Kingdom. That's coincidental, though. They were married. They returned to Israel to work and to have a family. And Benjamin's wife, Anne, became a permanent resident, but not a citizen, and did not convert to Judaism. They had children. And when the Shalit son was born, the parents attempted unsuccessfully to register their son and their daughter for complications in the laws changing, which I won't get into, as of no religion and of Jewish nationality, right? In these two categories, dat and le'um. And they were told, for the purposes of the population registry, that they could not do this, that you couldn't have no religion, but have le'um in the Jewish in the nationality category. So Shalit took this case all the way to the Supreme Court, where he won. However, the Knesset, due to coalition politics, responded by amending both the law of return and the law of the population registry in very specific ways that allowed religion and nationality to be split for the purposes of the former. In other words, so that you could still immigrate if you were not halakhically Jewish, but not for the case of the latter, which you could not say that you were of Jewish nationality but not of Jewish religion. So to get to the comparison, there are differences between the two cases. The JFS case is obviously about admission criteria for schools, whereas Shalit is about a population registry. In the JFS case, the mother had converted and the father was making an argument for a religious understanding of the child's Jewishness. And in the Shalit case was almost the diametrical opposite, where the mother had not converted and the father was arguing for an entirely secular understanding of Jewish nationality. But there are also striking similarities. In both cases, this is the father who has been intermarried who is fighting the case on behalf of the child. In both cases, the decision actually had no bearing on the life of the child in a real way that I can see, and so this is a highly symbolic fight. In other words, by the time they went to the Supreme Court in the UK, the kid had already been placed in a school. I think he was maybe almost finished in a different school. And in the case of the population registry, it's just a population registry, right? It's something different from the Rabinovich. It, to my understanding, does not have practical implications, but I could be wrong. In both cases, the justices in the majority studiously attempted to avoid the intermarriage question that was at the heart of the matter. In the majority, the minority was a different case, and in both cases, the justices in the majority practically shouted that they were not determining criteria for who was a Jew, when of course they were. Okay, so it's clear that in both cases the Supreme Courts had little interest in being dragged into the dispute, and actually in both cases the decisions, they actually verbalize that and say, we wish we weren't having to decide this. In the Shalit case, the justices in the majority went out of their way to emphasize that, as they saw it, the question before them was about the narrow issue of whether the population registry must consider a citizen's registration based on self-ascription. In other words, do they just have to listen? Do the bureaucrats have to listen to the person who's giving their answer? A second opinion in the majority, Justice Berenson, assented with the decision, but on a different grounds. He said that what was at stake was a question of whether Jew is a nationality, and his opinion was that the court should reflect public opinion at the time, which he believed affirmed the Shalit's view, which was that Jew is a nationality distinct from religion. And there's only one justice in dissent, who I'll come back to briefly, who was willing to rule on the question of whether the Shalit's children were Jewish, and believed that that was actually the question at hand, answering quite adamantly that they are not. In the JFS case, each of the Lord Justices attempted to decide the case according to conformity to English law, without weighing in on the matter of how the chief rabbi should define being Jewish. But most found it difficult to do one without the other, and there's some very contradictory statements in the decision itself. In both cases, despite attempts to narrow the decision, the judges were being called on to determine whether parents, or specifically intermarried fathers, had the right to define the qualitative nature of their children's Jewishness for full benefits of membership in the community, or whether that right is a right controlled by an official, whether in the office of the chief rabbi in the UK or the state bureaucracy in Israel. And even though Jews are a minority in the UK and a majority in Israel, as I don't need to tell people here, Israel inherited a modified legal structure from the British mandate with some Ottoman stuff thrown in. But the structure is fairly similar, and both face the same problems. In Israel, the question is further complicated by the ramifications of some of these questions in terms of qualification for citizenship. In both places, being Jewish is widely understood as being part of a shared culture and history that includes but is not solely defined by religion. But admission to the group and membership is mediated by a state-recognized religious authority at the expense of other religious authorities, because both Israel and the United Kingdom grant an official monopoly to one particular group. In the JFS case, no one on the court challenged the state-sanctioned monopoly of the Orthodox rabbinate in the UK to determine membership in the group. This actually surprised me when I read it. Access to religious education, or even the idea that all Jews of matrilineal Jewish descent are Jewish regardless of religious practice. Though one dissent did suggest that the office of the chief rabbi didn't adequately represent all British Jews, nobody actually challenged this monopoly, this sort of autonomous right that they had. Yeah. Not on my watch. It's not, but okay. Fine. Pardon? That's fine. Okay. So, So I will move along quicker and say that the court itself did not. It agreed. The majority agreed that that the Orthodox could maintain this monopoly. They never said that the office of the chief rabbi should recognize Masorti conversion, patrilineal descent, or membership based on self-ascription. It simply said that in its state-funded communal structures, such as education, it must follow British law, which it determined to mean not discriminating against members of its own group on ethnic grounds. And they determined that this had happened because the student was not admitted based on who his mother was, not what her religion was. And I had a selection to read about just how adamantly the justices really expressed that they did not want to be, they weren't challenging sort of the given rights of the community. The crux of the JFS's argument against admitting the child was that freedom of religion protects the autonomous existence of religious community. And the court unanimously accepted that position. And the abbreviated version about what I have to say about that is that you have a strange situation in which all parties in this case are insisting that the Jews are a religion, right? The office of the chief rabbi, the JFS, and the plaintiff are insisting that the Jews are a religion, and the justices are saying, we can all agree that the Jews are a nationality, because in order for them not to be exempt from laws on discrimination, they have to treat the Jews as a nationality because they're allowed to discriminate on the basis of religion. And the court assumed that this was sort of a utilitarian tactic to say on the part of the official community that they were a religion. But I would suggest that we should take it as sincere, because within, as we know, within a political system in which sovereignty is defined from of belonging to the people, right? To say you are not of the people has a particular significance, which I don't think is one in which the JFS was attempting to embrace. In terms of the scholarship on the matter, and I will give an abbreviated version of that, in both people having written about the JFS case and the Shalit case, and it's incredible with the JFS case how quickly this has produced just enormous amounts of literature on it. But there is virtual, or everything I have read is in agreement on this critique that the Supreme Court did not view the Jews on their own terms, and that they essentially took their own Protestant lens and they said, well, you know, there should be some sort of test based on practice or something other than dissent, and sort of Protestantize the Jews. And in fact, there was a recent article in the Yale Humanities and Law Journal that made the exact same argument about the Shalit case, that said that actually these Jewish justices were themselves sort of viewing secular through a Protestant lens. I mean, I would say that I don't buy it. If you read what they actually say, there is nothing even remotely Protestant about it. They use terms like saying that nationality, ethnicity, and religion for the Jews is virtually coextensive, and there are long discourses in majority and dissent on the fact that they are not challenging the matrilineal descent-based understanding of Jewishness, as this had let them survive, and so on and so forth. And it's interesting that the British justices, their argument most clearly resembles the vociferous dissent in the Supreme Court case over Shalit, where you have Justice Silberg, who states also explicitly that Jewish religion and nationality have been coextensive, and that's why we can't allow these things to be split off. To conclude, I would conclude by raising the question I brought up at the beginning, which is why intermarriage in particular is such a contentious site of debate over determining who is a Jew. There have also, of course, been legal fights over this definition related to individuals who have converted to Christianity, or whole communities who define themselves as Jewish but aren't regarded as such by the Israeli rabbinate. But I would suggest that intermarriage seems to be proved particularly bloody when it comes to defining the questions of who is a Jew. And you might say, okay, well, the answer is obvious. This is about collective survival. But actually, it's not, right? As we heard earlier, intermarriage does not necessarily challenge sort of collective survival, and also in these particular cases, neither attempted to challenge the status quo at all. These were more technical matters. And I think in these particular cases, what you see is something more visceral and something more abstract, which is a father's right to determine his child's membership in his community. And that is something I think felt acutely that goes beyond these two particular cases.